All right, everyone. We start? Ready? I promised last time. I promise. Oh, God. Last class. Thank you so much. This is very sweet of you. And I suppose this is a prelude to your grading because I will blank spaces and I'll write your names. I just made that up, too. I got stuff for you, too. This one you can actually eat. So, Costa did a good job. So, enjoy. Take as many as you can. I don't want to bring anything home. Go. Take them all. I don't want to bring it home. But thank you all very much. It's a very sweet gesture. You've been a wonderful class. I know you don't believe me, but this has been more a joy for me than for you. I know you don't believe that. I learn more from you than you'll ever know. Every day I'm in here, as I'm teaching, I'm thinking more of this topic that I love so much, and I get to refine my ideas. You ask me a question like, wow, that's a good question. Let me think that more. So you've had an influence on me and the law in ways you'll never appreciate. And I'm very confident that what you've learned in this class will serve you the rest of your lives in ways you may not appreciate now, but I'm confident that it will. So thank you all so much. Give yourselves a round of applause for all of you. I think the last time I had a CD, I don't know if I've actually had a music CD, but I don't even try it anymore. I'll find a way. I'll find a way. Anyway, all right. So last class, and hopefully this will be an interesting one. Any questions? Anything in your mind about the First Amendment, speech, or religion? Anything in your mind about anything else? Okay, so I'm sure as all of you know well, your exam's on the 15th. I've done this a dozen times. I'll do it again. Your exam's on the 15th. We'll have a review session on the 13th. If you go to the syllabus, there's a sample review question. It's a question about Obamacare in the 1930s. It's a good question. We'll be doing that question in class. If you go to the syllabus, it's been there the entire semester, so there's no surprises. If you've already done it, wonderful. If not, this is your chance. So it's going to go down like this. We'll be in this room, what is it, at noon? Yeah, so this room at noon. You'll come in. I'll hand out the papers, proctor it, 90 minutes. Take it for real. Let me make this very clear. The word counts. 1,000 words per question. Not 1,000 characters per question. I swear, I had one property student last year who the word limit was 500. She wrote 500 characters. So if those of you use Twitter, that's basically 4 tweets. Yeah. That's like 3 sentences. The student did not do well. Don't do that. The word count feature in ExamSoft is, I mean, not the most intuitive thing, but you have the software, you have like a sample test, run it, and make sure you know how to do a word count. Don't screw this up the day of the exam. Anything beyond 1,000 words, I'm going to stop reading. Why am I using a word count? This is more of an issue in property than in ConLaw, but it's a matter of fairness. When I was in law school, I could write a lot. I could spill 3,000 words in an exam and just dump everything I know, praying that I'll hit the right answer, right? To use the image of today, perhaps machine gun fire, just spraying everywhere, right? That's a bad way to write an exam. By using a word limit, I can judge everyone on the exact same canvas. You have 1,000 words, and you have 1,000 words, and you have 1,000 words, okay? It makes it very easy to judge A to B. Okay? 1,000 words per question, so 2,000 words total. The other thing to think about and look at the questions is all my questions have subparts. Usually they have 5 subparts. So if you have a question of 1,000 word limit and you have 5 subparts, that means maybe you should have 200 words per question. It's not exact, but it's a rough guide to get you to know how much you're looking for. Okay? As I mentioned a couple times before, the format's like this. There are going to be 2 questions, 2 issue spotters. Exactly like the one I put on the website from last year. It'll be no different. The first one will be based on, or maybe the first or second, I don't know the order, but one of them will be based on the current Supreme Court, right? I will give you a question, the year is 2015. How will the justices decide the case, right? How will they decide this issue? To preempt your question, if the judges decide anything in the next week or so, don't worry about it. But I haven't read the question, so I have no idea what it's going to be. Okay. The other question will be one of historical. The year will be, I don't know, 1936, 1868, 1791, some sort of very important epoch, right? This won't be like 1997, some random year. It'll be a fairly significant year in the court's jurisprudence, which we've discussed at length. And I'll make it abundantly clear why it's important, and you should know also. People always ask me about outlining your notes. In your outline, you should have the years for cases. That way, if the year is 1936, you shouldn't be citing cases from the 1950s because they haven't happened yet. Of course, you can use your foresight to try and see what the court should do, but you should not be relying on cases not yet decided. Okay? Mere recitation of the black letter law is not going to help you very much. That's why I don't spend much time on it, like memorizing the elements of a libel. I still don't know what this is, right? So you need to be able to understand the facts. So look at the exam question put up from last year, the sample one about the Affordable Care Act implemented during the 1930s. You need to figure out, okay, we have this Commerce Clause case called Wickard that hasn't been decided yet. Okay, how can the government regulate health insurance when Wickard hasn't been decided yet? That forces you to think about the evolution of the doctrine of how far they went before 1936. You can't just say, oh yeah, Wickard, commerce means everything. It forces you to think about this. Okay, I'd also encourage you to look at the sample answer. I put up the A+ answer from last year. It's one of your classmates from the previous semester. Take a look what that student did. And you'll see more or less what I'm looking for. Time won't be your enemy. There are only 2 questions. You're going to have 3 hours. I mean, give yourself 90 minutes a question. I don't think you'll need it. Most students tell me they finish with time to spare, but you're welcome to take as much time as you want. Use that extra time to go over and proofread. I think this is your last exam. So burnout. You don't know anything else after that, right? stay till the end. Don't give that time up, right? You're not, as they say, leave everything on the court, as the expression goes, right? Don't leave anything out there. Yes.
So if something happens like that happened a year before, we shouldn't like infer that because like a year later the court.
You can discuss. I mean, so that question particularly, you can say the trend of the court has been going in this direction, but you can't say, well, Wickard held that substantial effect, blah blah blah. That hasn't happened yet, right? The purpose is I want you to try to understand how the judges in that year would have decided the case.
So you pretend not to know the future.
You don't know the future. You can speculate about which direction the court's trending, but those aren't rules of decision, right? Those aren't bases on which a court can decide a case. All right. Yes, sir. No. Come to your choice, right? You can come to class, sit. I'll give you 90 minutes. You can type it in class, or you can do it at home and come for the review. I don't care where you do it. I give the opportunity here because you have a quiet room. It's settled. People may have distractions at home, so here it's a setting for you to do it. Hector?
So when you give us the year, are we supposed to assume that that the decision in that year should be included? In other words, are we sitting on December 31st of that year or January?
Assume it's December 31st, right? I'll probably give you a date, or I'll say it's the end of the Supreme Court's term in 1936. Something. I'll make it clear. I'm not going to try and trick you up on cases decided April 15th and today's April 3rd. I'm not going to. I can trip you up on much more difficult things than that. That's not what I'm trying to trip you up on, right? I'll say, in that question, like it's the eve of West Coast Hotel v. Parish, that switch in time to save none. Like, it's right at this cusp, or like, the 14th Amendment was just ratified last week, right? It's something really momentous. Okay. Other questions? What else? I know you have more questions. You're lying if you don't. And I'm impressed how many people are here today. I was afraid I have too many cookies. Keep passing them around. Get them around. I bought enough for like 100, so you can all take several. Okay. Look at these guys hoarding the cookies. I know that works. All right. What else? Anything else in your exam? Anything else thinking? Going once? Going twice? All right. And again, any questions you want, email me. I'll be around. Okay. So today our discussion is on the Second Amendment of the Constitution. And this is a topic that's very interesting to teach. Because when I started law school not too long ago, the Second Amendment didn't really mean anything. It didn't really have any meaning. If you looked at the ConLaw textbook I had when I was a 2L, there would not have been more than a paragraph on the Second Amendment. There would have been a paragraph on it. Law school, on the other hand, the Second Amendment became a real thing. Okay? Before we get to the history of the Second Amendment and how the framers drafted it and what it meant and how it was intended, it's an interesting study to discuss how has the Second Amendment evolved over the last 200 years. Okay? So we start from the premise that until the 1940s and 50s, the Bill of Rights didn't really mean much because it had not yet been applied to the states. Think of the very early First Amendment cases we studied. It was in the readings. In the early days of the 20th century, people were arrested for speaking out against the government. Eugene Debs, a socialist, was thrown in jail for preaching against the draft. Okay? People could be thrown in jail for opposing the war. And you might say, how could it be that the First Amendment, right there, number one, allowed this? And it wasn't until the 1930s and 40s and 50s and really 60s and 70s that the First Amendment came to be what we know it is today, a protection of an individual right to speak out and express yourself. And I'm sure you studied in criminal procedure. If you haven't, you will soon. That the Fourth Amendment didn't really mean much also during this time period. The warrant requirements, Miranda, grand jury, a lot of the key cornerstones protections of our Bill of Rights didn't really mean much into the 20th century. So in the 1930s, 40s, 50s, 60s, one right after another was addressed by the court. Free speech, free religion, freedom of association, due process, abortion, birth control, right? One after another, each provision was hit. Criminal procedure, Miranda v. Arizona, Terry v. Ohio, search warrants, one after another. The death penalty, the Eighth Amendment, that came to the forefront. During this period, virtually every single amendment Bill of Rights came before the court as the court started recognizing this host of new individual liberties. Except for one, the loneliest right. You may recall that in Justice Douglas's opinion, Griswold v. Connecticut, remember the penumbras from the emanations? Remember this one? He listed all these different rights about how people have these privacy rights. He listed, free speech and even quartering of troops. But nowhere did he mention the Second Amendment. Monish and no. Why is this right different from all other rights? Okay, why is this right, Second Amendment, left out? I don't have an answer for you, right? I don't know why it was left out. But for a significant period of time, at least in legal circles, the Second Amendment was understood as the Heller dissenters say it was. This was merely a right controlling the militia, and it in no way impacts or in no way affects the rights of law-abiding citizens to keep guns. They said, we don't need a Second Amendment because virtually every state constitution has a guarantee to bear arms. Let the states protect guns. Why is the federal government to protect it, right? Why should we impose a single federal standard on every state that wants to protect guns? Okay? And for much of American history, this wasn't an issue. There were very few federal laws concerning guns. There just weren't many. Right? Gun control, to the extent that existed, was a province of the state. That changed, as in many things, during the Roosevelt era, as much of our civilization changed. And Congress passed something called the National Firearms Act, the NFA, which is effectively still in effect today. And what this law said was, we want to regulate the sale of certain types of guns, automatic weapons, what you might call a machine gun, and a short-barreled shotgun. This is a shotgun that you saw off the barrel, so it's easier to transport. And these weapons weren't banned, but you have to pay a significant tax on them, which was a form of government registration. Okay. This was really the first case testing the federal government's power to regulate firearms. And it was called United States versus Miller. This was mentioned in the opinion a couple places. And Miller, who was some, two-bit crook, was busted for possession of a sawed-off shotgun. He had this gun. And he was prosecuted. And his lawyer, God bless him, said, you know what? We're going to challenge this in the Second Amendment, right? We're going to raise as a defense that this prosecution is void under the Second Amendment. And this case went to the Supreme Court because the lower court ruled in favor of Miller. And in a 9-0 opinion, Justice McReynolds ruled against Miller. By the way, by the time the court decided this case, Miller was dead. He died while the case was pending. And oh, by the way, he was so poor, he couldn't afford to send a lawyer to the Supreme Court to argue on his behalf. So this was a case where only the government argued against itself, right? There was no actual representation for Miller. And he died before the case was decided, which effectively moots it, but we don't, those things don't matter anymore. And the court said a few things, right? They said that the type of weapon that the government sought to regulate in Miller was not the sort of weapon that would be used in the militia. And then it said some stuff about how the Second Amendment is, connected to the militias. It's a very obtuse opinion, and you can read if you want if you're ever bored. But you can see how the majority and dissent kind of argue over it, and I'll concede it. It's not very clear exactly what he was saying. Justice McReynolds had better days. But whatever Miller actually said, the law professoriate took on the mantle of saying that the Second Amendment only applies to members of the militia. Look, it says right there, the militia, right? And over the next 60 years or so, virtually every law student in the country, every lawyer came of age thinking that the Second Amendment was a dead letter. It didn't really mean much. Chief Justice Warren Burger, in an interview in the most cutting-edge legal periodical, Parade Magazine, that was a joke, gave an interview where he said that the Second Amendment as an individual right is a fraud. Let me repeat that. He said a complete fraud. So the Chief Justice of the United States, I think this was 1988 or 89, something like that, said that the Second Amendment, the idea that the Second Amendment gives an individual right to bear arms was a fraud. So how did we go from a case like Miller, the text of the amendment, which I put up right here, and the Chief Justice of the United States, not a very good one, but the Chief Justice insisting that the Second Amendment is a fraud if it protects individual right? How did this happen? And this is really the story of legal persuasion in a way that few people recognize. So throughout the 1970s and 80s, there were a number of legal scholars who started digging into the history of the Second Amendment and said, hey, wait a minute, right? Yeah, it's just stuff about the militia, right? But there's also all this stuff about how the Second Amendment guards individuals, how it protects self-defense, how it guards us from not just the federal government, but tyrannical governments everywhere. And all this historical research I'm pouring out in the 1970s and 80s, led by a guy named Don Cates, who you'll never even know, but he's a very interesting guy. And the argument started to germinate. And this is how persuasion happens. Scholars write articles. New history is discovered. People say, wait a minute, maybe what we've been holding dear for 7 years isn't correct. I think the turning point came in the late 1980s when Sandy Levinson, who teaches at UT Austin, wrote an article called The Embarrassing Second Amendment. The Embarrassing Second Amendment. And Levinson, who's a liberal, I mean, he wants to repeal the entire Constitution and impose a parliamentary government, right? This is not some sort of NRA flamethrower here, right? Levinson said, we've screwed up, right? Constitutional law professors have been so blinded by this militia business that we haven't looked at the actual history of the Second Amendment and how it came to be. And Levinson, and again, this is he's a left-wing guy, said this protects the individual right. It doesn't mean there can't be gun control, make no mistake, but that this entire militia argument isn't the entire story. And after, around the time that Levinson did that, people like Lawrence Tribe at Harvard and other very prominent legal scholars at Lamar and others started saying, wait a minute, this militia business, I think we may have jumped the gun here, right? No pun intended. I think we may have been a little bit too quick to embrace this militia thing, right? And then throughout the 1990s, there were a couple really big gun cases that weren't gun cases, and you study them. So first we had United States versus Lopez. This was a Gun-Free School Zone Act case, right? Could Congress prohibit the possession of guns in the school zone? Now, when we study this, the word Second Amendment never touched my lips. I never mentioned it. But make no mistake that people are saying, wait a minute, what gives the federal government the right to regulate guns in the states? Lurking in the background was the Second Amendment. And then we had another gun case, which you probably didn't think much of, but had a Second Amendment angle, was United States versus Prince. This was a commandeering case, right? Remember where the sheriffs were required to run background checks under the Brady Act to see if a person was able to purchase a gun. Do you know who Prince was? He was an NRA board member. There was no accident here, right? This was, of course, a federalism case up front, but lurking in the background was, wait a minute, why is the federal government regulating guns? Why are they intruding into this area that was once historically the province of the states? And in Prince, Justice Thomas wrote a very important concurring opinion. Justice Thomas does this all the time. He's very good at this. He says, the parties did not raise the Second Amendment here, so we don't need to consider it here. But perhaps at some future date, this court will have the opportunity to determine what the Second Amendment originally means. Thomas does this very often. You're like, well, you guys didn't raise this here, but you probably should have. And oh, by the way, I'm open to revisiting this Miller case because I don't think it says what you think it says. I don't think Miller means that. So Prince was about 97 or 98. And then we had another case from the Fifth Circuit right here in, I think it was a Louisiana case, Emerson, where a panel of the Fifth Circuit basically said that the Second Amendment guarantees an individual right. That case did not go to the Supreme Court. They did not certiorari. So here we are leading into the early 2000s, right? You have Justice Thomas, you have some federal appellate judges, you have these law professors trying to say, wait a minute. This Second Amendment business, I think we screwed this up. So what do you do? What do you do? At the time, virtually every place in the country allowed the ownership of guns, handguns at least. The only exceptions, for the most part, were the District of Columbia, the seat of government, and Chicago. And those cities showed no interest in allowing the registration of handguns. Their Illinois state constitution had no right to bear arms provision. So what do you do? Well, the NRA, who I'm sure you're familiar with, the National Firearm Association, the National Rifle Association, had a choice. Do we litigate this? Do we take to the Supreme Court a case challenging the right to keep and bear arms? Well, there's an upside and there's a downside. Both are named Justice Anthony Kennedy. Well, I'm not joking. So in the early 2000s, we didn't have John Roberts. We didn't have Sam Alito. We had William Rehnquist and Sandra Day O'Connor. And Justice O'Connor, although she was a Western girl from Arizona, lived on the ranch, no one knew how she would vote on this. Same for Justice Kennedy. He's been over the map since since his appointment to the court. So the NRA made the decision not to bring any case. They said it's too risky. They said we'd rather maintain the status quo, where the Second Amendment doesn't mean anything, than take up a case, lose 5-4, and prove the Second Amendment means nothing. In other words, this would embolden governments to regulate guns even more. You know, I mean, we're living through an argument at the moment, which I'm not watching because I'm teaching, but as we speak, at this very instant, the same-sex marriage case is being argued in Washington. Similar arguments were being made. The risk was, well, if we bring this case too early and the justices rule against us, then we'll have no right to gay marriage. That might be worse than maintaining the status quo of letting the political process work out. In fact, Ted Olson and David Boies, when they filed this case in 2008, roughly 7 years ago, that was the fear that the justices are not ready, they'll rule against us, they'll screw everything up. Things went as they went. But there's always a risk when you bring these sorts of cases, a lesson I know very well, that they backfire. So the NRA said, we're not going to bring this case. So contrary to as much credit the NRA takes for Heller, they were not behind it. And in fact, they not only opposed it, they tried to sabotage it. Oh yes, they did. I know this because while I was in law school, I was a research assistant to the lawyer who brought Heller, who's now a good friend named Alan Gura. So I have a deep history with this case. My law school, George Mason, was basically ground zero for the Second Amendment. Of the 4 Second Amendment law professors in the country, I think 3 taught at my school. There were not many elsewhere, so I bring a special perspective on this. So how did Heller begin? A couple names you've probably never heard of. So one guy named Clark Neely, okay, another guy named Steve Simpson, and Bob Levy. Okay, these were libertarian lawyers who lived who were in Virginia, and they said, you know what? We need to bring a case to recognize the Second Amendment means something, right? And Bob Levy, who's an alum of my law school, bankrolled this case. And they hired a lawyer named Alan Gura, G-U-R-A, who's a dear friend of mine. And they followed this lawsuit in the District of Columbia. The case was originally called Parker versus District of Columbia, not Heller. Heller got some attention later. But originally it was Shelley Parker. Okay. Why did they file in the District of Columbia? Why didn't they file in Chicago? I want to take a guess. Why do you think they would start in the D.C.? Come on, it's a tough question. Yeah.
Because the Supreme Court's going to be your binding court. It's the fastest way to get to the Supreme Court.
No, they're
Just a symbolic thing?
no.
It's not a state.
Yes, and what do they not have to worry about? How do amendments apply? How does the amendment apply to the states? What's that process called? Incorporation. By filing in D.C., they don't have to worry about incorporation. That was stage 2. That became McDonald v. Chicago. But by filing in D.C., they go straight to the Second Amendment. There's no need to talk about incorporation. Okay? So the case was filed in the District of Columbia. Now, as the case discusses in the District of Columbia, you couldn't register a firearm, right? You couldn't register it. So imagine you're Dick Heller. This is what he looks like, right? You're Dick Heller. You work for the Federal Judicial Center. He was a security officer. He worked for the courts. His job was to protect judges. Okay, so during the day he was allowed to keep a gun to protect judges, and at night when he went back to his really not very nice neighborhood in D.C. where he lived, he had to give his gun back. So if you're Dick Heller, like, okay, you know what? I don't feel safe in my home. I'm going to go to the police department and say, I would like to register a gun, right? I would like a permit to buy a handgun. Okay, so Dick Heller went down to the police department. He's like, I'd like to register to have a handgun. And they said, no, we have no such process. You can't register a gun because we have no law to provide for it. Sorry, too bad. That act, that futile act of going to obtain a permit which cannot be obtained was so important. You want to know why? I want to guess? What did that denial give him? Standing. That's why the case is called Heller and not Parker. All the other plaintiffs just filed this lawsuit. They never bothered trying to actually obtain the damn permit. But Dick Heller, who's an arrogant SOB, man, I mean, he's an interesting guy. Google him. He's an interesting guy. Had the foresight to go down and apply for a permit that he could not get. Mad genius, whatever. The fate of the universe hinged on that idiotic act. So, if any of you ever do any civil rights litigation, make sure your client gets told no. Because once he's told no, that means he has an injury. We fear for our safety, right? We fear, believe it. No, of course, it's sorry, not going to work. You should have asked for a gun first, even though you're going to be told no. So that's the world we live in. So Heller is an interesting guy. This is the picture I'm going to show you next to describe him. This is a very accurate picture of Heller. So the gun he's holding is a revolver, a pistol. I think it's a 6-shooter, a 5-shooter. He had that gun from the 1970s and been living in D.C. for decades. And originally in the 1970s, you could register a firearm. When the laws were changed in the 70s, the city said, okay, or the district said, we're not going to confiscate your guns, right? We're not there quite yet. But if you have one, it's now illegal. And, oh, by the way, at all times, you must keep it inoperable. This is what's called a lock. Basically, by having this lock on the gun, you can't do anything. You hit someone in the head with it, but it's not very useful, right? At all times in his home, he was required to keep his gun locked. Now, what if you say, Josh, what happens if someone broke into his house and was about to kill him? Could he unlock his gun? The answer is no. There was no self-defense exception. So someone could be breaking into his house, about to bash his skull in, and he would have to sit there with his locked firearm. Okay? I swear, during oral arguments, I swear this actually happened, the lawyer for the District of Columbia, a guy named Walter Dellinger, said he timed himself unlocking he went to the store and bought one of these locks at night, and he timed himself unlocking it at night in the dark. He said it only takes a few seconds. This was DC's defense of the law. It only takes a few seconds to unlock the gun, even though he could be prosecuted for illegal possession. This was the district's defense. You tell I know this case a little too well. Okay. So what did Heller do? Well, I told you he went to the city hall or police department and tried to register his gun. They said, sorry, no go. That gave him standing. And the action was filed in the district court by Gura and his lawyers. When Heller was filed, again, we didn't have John Roberts and Sam Alito. We had William Rehnquist and Sandra O'Connor. And the NRA was very afraid. They were saying, uh-oh, you guys are going to screw this up, right? We're going to get a 5-4 decision saying that there's no Second Amendment rights about the militia. This is going to screw things up. So the NRA actually tried to sabotage the case at several junctures. They tried to join parties who lacked standing to try and kill the case. They engaged in serious shenanigans. Fortunately, for history at least, those shenanigans didn't work. And the case went to the Supreme Court as District of Columbia v. Heller. Why was DC's named first? Because the DC Circuit ruled in favor of the Second Amendment right to keep and bear arms, not the city or the district. Right? So that's a brief history of Heller. If you're really interested, there's a book by a guy named Adam Winkler called Gunfight, Winkler. It's a really good book. I recommend it. It's one of the best books on Supreme Court case you'll ever read. And he does a very good job tracing the history of it. So I'd recommend it if you like the Second Amendment. Okay, so the case was argued in, I guess, in the fall of 2007, and was decided June of 2008, not that long ago. Okay, any question about the history of the case? We did the history of the case where we got to the history of the Second Amendment. Anything? All right, let's start. Let's start with the text of the amendment, as we should always do. And the text of the Second Amendment reads, "A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed," period. So why am I pronouncing the punctuation if you don't bother that? The reason why is that each clause has taken on a life of its own. And if you ever go to visit the NRA's headquarters in Fairfax, Virginia, they have a very nice range there and an excellent cafeteria, I should add. It's really good. It's really good. There's a huge banner when you first walk in with the second half of the Second Amendment printed. First half's not there. No ellipsis either, no dot, dot, dot. It just says, the right of the people to keep and bear arms shall not be infringed. I mean, it's you can't miss. It's a humongous sign when you first walk into the building, right? Similarly, there was a great book written by, or not, it was a very, very popular book written by Saul Cornell, who's a professor who doesn't very much like the Second Amendment. And the title of his book was A Well-Regulated Militia. So one of the leading books concerning gun control was called A Well-Regulated Militia. So we have these two clauses separated by commas that are seemingly pointing in absolutely different directions. And this fractured the court by a 5-4 vote. And even though Heller was already decided, this issue has not been left quiet. Justice Stevens, who wrote the dissent, which is in your book, wrote a book a couple of years ago called, what was it called? 5 Amendments or 6 Amendments, whatever it was, right? It wasn't very good. The amendments were, I mean, they're not well drafted, and I can explain why later, but they're, thank God he wasn't James Madison. His drafting was not good. But one of his amendments was basically to overturn Heller. He says we need to come back to having a militia-based Second Amendment. So this issue is not dead. People still are very passionate about it. So let's talk about the two amendments. Let's do the first one first. Now, Justice Scalia calls this first part the prefatory clause. Have you ever heard this word before? The prefatory clause, like a preface to a book or preview. The prefatory clause of Scalia is a thing that comes before it, like a preview. Justice Scalia calls the second half the operative clause. You have the prefatory clause, and you have the operative clause, the substance or the operation of it. Justice Stevens came in agreeing what to call the damn things, right? These are dangling participles. Justice Stevens calls this the preamble. Where have you heard the word preamble before? Well, that's the beginning of the Constitution. We the people of the United States, right? This is setting forth this inspirational message which guides the entire document. If you ask Justice Scalia, prefatory clause doesn't really mean much. It's just, whatever, militias are important. If you ask Justice Stevens, the preamble. This is the core of the Second Amendment. All this other stuff is, secondary. It doesn't really matter. But before we go to either Scalia or Stevens, we have the threshold question, which is, why should this history even matter? Why should the courts be guided by the proverbial dead hand? Why should the hand of the framers who lived 200 years ago in a very different time even matter? What's fascinating about Heller, and this is a tribute to what's been called originalism, is that all 9 justices are fighting about what the original meaning of the Constitution is. It wasn't the case that the dissent said, who gives a damn what the framers thought. We live in the year 2008. No one said that. Justice Stevens fought on the originals of Battleground. He said, fine, Scalia, you want to do history? I'll do history, right? You got your historians, I got my historians. You have your linguists, I have my linguists. Who wins when you have battles of histories? You have your dictionaries, I have my dictionaries from the 1700s, right? This case is a microcosm for the battle over originals and methods become, where now you have two very well-respected judges looking at the exact same 20 whatever words with the same history behind them, reaching such diverging conclusions of law. What does this say about the endeavor of originalism? If judges can reach results that match their desires, does originalism have much force? Can anything be different said about the judges in the 1960s and 70s who said we have a living constitution and the constitution means whatever we feel like today? Is there something about history that grounds you in a way that living constitutionalism doesn't? Or is originalism nothing more than just a veneer to achieve this? This is a debate that has been going on for longer than any of us will ever be around. But the majority and dissenting opinions in Heller put a very, very fine point on this debate. Okay, so let's start. A well-regulated militia. What does this mean, a well-regulated militia? Well, to understand that, we need to look at other provisions of the Constitution, which you probably never paid much attention to, which is Article 1, Section 8. Okay? Article 1, Section 8. This is part of the Constitution I never even bothered reading, but it's in there. Congress has the power to provide for calling forth the militia. Wait, what's this militia? What's this militia business? What is this militia? This may come as a surprise to most people today who live in the world where the United States has a standing army of, what, 1 million people? I mean, it's got to be, it's more than, it's, in the millions, right? I think, if I remember correctly, that the United States military is the largest employer, followed closely by Walmart. So just to give you a sense of how many employees, this was true years ago. I don't know if it's still true. Peace dividend and all. But we have today a massive military. They have bases all over the country, and indeed all over the world, increasing number of countries as I teach this class, right? This was not always the case. In the 16 and 1700s, the idea of a standing army was feared, right? Why was a standing army feared? Because if there was a group of trained men, and sorry, there were no ladies, but if there were a group of trained men loyal to the king, on the king's payroll, they could do whatever the king bids. They could oppress the people, they could take property, they could kill people, do whatever they wanted. So what was the only way to check the power of the king? He could not maintain a standing army. If there was a war, an invasion, fine, call up the people, let the people fight, and then when that war is over, let them go home. Let them beat their swords to plowshares, right? Like Cincinnatus. In our own founding era, standing armies were a danger. In the colonial times, the Brits kept standing armies in the cities of Boston, of New York, in Philadelphia, in all of our cities. And the standing armies did something they always did. When they feared an insurrection, what's the first thing the standing armies do? Come on, Texas. Come and get it. What do standing armies do when they fear insurrection? How? They take their guns. Yes, everyone know the battle flag of Gonzales, right? Come and take it. The Battle of Thermopylae. I went to a Buc-ee's near there once, right? I was really tempted to go, but I was in a hurry. But I went to the Buc-ee's nearby on the way to Austin or San Antonio. Right? In the history of the world, when you have a standing army that fears an insurrection, one of the first things they do is they seize guns. This period has repeated itself more often than we can even count. During the British Revolution in the 1600s, right? They seized all the guns of the people. During the siege of Boston in the United States by the Brits, they seized all the weapons. I don't know if any of you studied this before, but one of the first acts that Hitler did when he came to power was to seize all the guns of the Jews. Yes, among the first Nuremberg laws were actually the seizures of guns. It's a long-standing history that the easiest way to oppress people is to take away their self-defense. It's not a mystery. And if you'll indulge me for a minute, Judge Alex Kaczynski, who I'm sure you're familiar with, issued an opinion in a case in the Second Amendment, and he referred to this provision as what's called the Doomsday Provision. And let me read this to you because it's powerful. By the way, he escaped communism from Romania at a very young age. He writes, "All too many of the other great tragedies of history, Stalin's atrocities, the killing fields of Cambodia, the Holocaust, to name a few, were perpetrated by armed troops against an unarmed population. Many well could have been avoided or mitigated had the perpetrators known their intended victims were equipped with a rifle and 20 bullets apiece. If a few hundred Jewish fighters in the Warsaw Ghetto could hold off the Nazis for almost a month with only a handful of weapons, 6 million Jews armed with rifles could not so easily have been herded into cattle cars. My colleagues have forgotten these bitter lessons of history. The prospect of tyranny may not grab the headlines the way vivid stories of gun crime routinely do. But few saw the Third Reich coming until it's too late. The Second Amendment is a doomsday provision, one designed for those exceptionally rare circumstances where all other rights have failed, where the government refuses to stand for re-election and silences those who protest, where courts have lost the courage to oppose or can find no one to enforce their decrees. However improbable these contingencies may seem today, facing them unprepared is a mistake a free people get to make only once." So what Kaczynski is saying is that this right to bear arms is effectively plan B when all the rights fail. And he speaks of the Warsaw Ghetto, and this is actually a very moving story. If you ever go to Yad Vashem, which is a Holocaust museum in Israel, there's actually a exhibit on the Warsaw Ghetto Uprising, which I was very powerful and moved by. It's a very powerful museum. And there's actually a pistol, which was used to fend off the Nazis. And it was actually a Star of David carved into the handle, which I think is a fitting tribute to what Judge Kaczynski said. And for those of you who actually think that this can never happen, I'd encourage you to look what happened following Hurricane Katrina, a city not too far from here, where within the span of a couple of days, civil society collapsed. And I'm not joking, National Guardsmen went door to door seizing guns. 2005, New Orleans, 5-hour drive from here. So lest you think that this can't happen, it does, and it will. And don't be so naive to think that we're beyond that sort of regime, because as we said in the times of war, the laws fall silent. And don't kid yourselves for a second. Things like Korematsu cannot happen again. Not for a second. Don't, as Lisa, don't kid yourselves. All right? This was some of the philosophical background against which the Second Amendment was drafted. And in the founding era, there was a distinct fear that the federal government would become tyrannical. Remember this entire business about ambition checking ambition, right? This wasn't some sort of just philosophical whatever. There was a legitimate fear that the central government would become one of tyranny. And of course, while federalism would be a check against it, the ultimate check was that which allowed this country to be born in the first place, which is armed self-defense. Right? We just studied in the very first day of class the Declaration of Independence, which was effectively a document saying, listen, you guys have screwed with us so much, we don't want to do this, but we need to engage in a violent force against you to protect our rights. So the same generation, a decade later, when they were drafting the Constitution, had a similar sentiment. If you read, it's in the reading, I didn't assign it, but Federalist number 28 and Federalist number 46. Right? And basically what they say, and this is Madison and Hamilton, right, is that the only way to check against tyranny from the central government is to have the threat of force in the background. And these were the state militias, right? These state militias existed for the sole purpose that if the central government became tyrannical, the people were trained, were regulated, could rise up in arms and fight against this central government. I know this sounds conspiratorial, Alex Jones, InfoWars stuff, but this was a legitimate fear in the 1780s. So what was interesting was that in the original Constitution, who had the power of organizing and arming this militia? It was Congress, right? Congress paid for this militia. Congress organized it. So what's the danger here, right? What's the danger if Congress is regulating the state militias? What happens if Congress decides, you know what? We don't need these militias anymore. What if Congress decides, you know what? These militias don't need any guns. We don't trust them. There was the fear that Congress could disarm the state militias, that Congress could take away the weapons of the state militias, thereby giving themselves a blank check to engage in whatever tyrannical acts they sought to pursue. Right? We also see that the president is the commander-in-chief of the militias. The president's commander-in-chief of the militias. What if the president says, stand down, I'm going to take away your guns, and we're going to build a standing army to oppress the people? I know this sounds fanciful today, but this was a serious fear of the founding era. So let's go back to the Second Amendment. And this is Justice Stevens' argument, which I'm trying to describe as charitably as I can. Justice Stevens says, this provision was meant to prevent the federal government from disarming the state militias. That the state militias were so important to serve as a check on the central government that they needed to enshrine in the Constitution this, to ensure that the right of the people in the militia cannot be taken away. Okay? So to this view, right, the Second Amendment's limited only to protecting the people in the militia from having their guns taken away. To the dissent, it says nothing about private civilian ownership of guns. Any questions on this? I know I'm lecturing more, but I'm in the lecturing mood today. I don't know. Yeah.
I have a question. Obviously, this the appellate was charged in 08. So, well, these were certainly relevant years in kind of the Constitution, and even perhaps World War II. In this day and age, it is no longer possible for a militia to rise up against the government if the government were to try to oppress them. We have weapons of mass destruction. We have drones. Guns are not going to do
Really?
that.
So you're trying to tell me that a small band of ragtag people can't take down a city?
No, no.
No, I'm not joking. And by the way, who was called to service yesterday to put down the insurrection? So actually, the timing of this was actually perfect. I'd rather it not happen. But yesterday in Baltimore, I'm sure you're following the current events, at a certain point, the mayor basically declared a state of emergency, which then the governor then activates the National Guard. We do have a militia today. You don't even know it. You're basically in it. Basically, all able-bodied persons under the age of 40, you're all in the militia. Milestone. Congratulations. You are. Go read the Militia Act. It's in the U.S. Code, right? if you're an able-bodied person on the age of 40, used to be men, now it's men and women, you are now in the militia, okay? So congratulations, you're armed. I don't know if you ever noticed this, but has anyone ever taken the naturalization oath? Anyone ever take it? The naturalization oath.
Yeah.
Do you remember that bit about how you promise to take up arms against in service of your government? There's a provision of the naturalization oath where you promise to take up arms to support your government. Remember that one?
Not really.
Hugh, you remember it? Yeah. Did you find that line a little bit odd? Yeah, it's true. So we do have a militia today. But to address your bigger point, right? Could a small band of armed people take down a government? Vietnam? Fallujah? ISIS? Make no mistake, right? Drones are very cool because they blow stuff up, right? You know, bang, bang, whiz, bang. But military action happens on the ground. And it's impossible to defeat an enemy when you have people armed with small arms on the ground. You know, go watch me like Red Dawn or something, right? I don't know what would happen. I really don't. And last year when I taught this case, it was during the time of the Bundy standoff. Remember that? Remember that feels like forever ago, right? Remember this was the rancher in Nevada who felt that these federal agents were intruding on his property, the Bureau of Land Management, and basically you had a bunch of armed guys saying, okay, make us move. I remember teaching this exact topic last year. I said, okay, what happens when you have a bunch of armed guys saying, make us move? You now have people opening fire on them. Things get very dicey, as we're seeing in Baltimore and elsewhere, when people are saying, no, we don't want to do this. Make us. And the rule of law breaks down very quickly in those situations. I mentioned the example in Katrina with New Orleans. People, you call 911 in Hurricane Katrina, and no one answers the phone. Say, I have an emergency. They're like, sorry, we can't help you. There's 8 feet of water. Right? Our society is very fragile. I mean, we live in a city of Houston that's vulnerable to hurricanes. Anyone remember, was it Ike hit a couple years ago, or Rita? You call 911, no one answers, right? You call 911, it's like, sorry, we don't have anyone to help you. What happens then? Yeah.
Katrina, they went into people's guns, you said?
They went door to door demanding guns in homes.
I mean, wasn't this like a time when people were like needing guns? Like, they were kind of, a lot of people are on their own once that stay. I don't understand, like, I don't know.
Isn't that the lesson of history, though, right? In times of crisis, what's the government's primary interest? Protecting themselves. Not allowing people to defend themselves. So I think your point's well taken, right? When you call 911, please say, sorry, we can't help you. You would want to be armed to help you. This is basically Kaczynski's point, and I don't this is not necessarily the resolution of the gun control debate. But Kaczynski's point is, the decision to give up your guns is a decision you make once. You don't get to make that one again, right? Once it's gone, it's basically gone. And then when you have a situation where the government can't help you, you are on your own. Right? That doesn't resolve the debate in any way, nor discuss this case. But it's a decision which society gets to make once, and which the Supreme Court said was not made 200 years ago. So we have this clause, since we have well-regulated militia, right? So we have this state militia kind of lurking in the background. What's the next clause? Necessary, the security of a free state. What's this talking about? Well, as we mentioned a moment ago, we're not talking about a free state like in Virginia or North Carolina, but state as in the broader polity, the nation, right? A free state, in order for our country to be free, we need these people in the militia to be able to protect us from this tyrannical federal government, right? Yeah, get this entire business about ambition, checking ambition. This wasn't just philosophy. This was a legitimate fear of armed insurrection, right? These weren't fleeting concerns of philosopher kings. These were legitimate fears. Okay, so we have this first clause, which articulates a need for a militia independent of the federal government to protect us as free people. Okay, everyone get that much. Okay, the second clause, which Justice Scalia refers to as the operative clause, has 3 important provisions. And you'll see both Scalia and Stevens go through these provisions in varying different ways. So first, what is this right of the people, right? Well, we see this word right in a lot of ways. You have the right of free speech, you have the right of freedom of religion, the right of free exercise. This word right appears throughout the Constitution. What does this mean, the right of the people? We often think of liberty as an individual right. I can speak freely what's on my mind. I can practice religion of my choice, right? I can associate with whom I choose. What is this right of the people? Is this a right that I can exercise by myself? Or is this a right I can exercise collectively? A collective right. So the majority says this is ridiculous, right? All the provisions in the Bill of Rights are of individual nature. Free speech, freedom of religion, search and seizure, right? These aren't rights you can exercise collectively. But dissent says, wait a minute. Who are the people? The people of the militia, the dissent says. That the people who exercise are not just whatever people. If you go back to the first clause, it's the people of the militia who get to exercise this right. But to this, what does the majority reply? Who's in the militia? Everyone. The militia is all of you, right? And if everyone's in the militia, then everyone has this right individually. You see, it goes back and forth like a ping pong ball, right? However many good arguments Scalia has, Stevens has, goes back and forth. And I don't expect you to make up your mind entirely based on the text, but at least understand the different perspectives. One other point. It doesn't say citizens, right? It says people. Does the Constitution apply to non-citizens? Can a person, if a person's traveling from another country, say visiting Texas from, I don't know, Canada, whatever, right? Whatever example, right? And that person's arrested, do they need to read your Miranda rights? Can they search your hotel room without a warrant? If they arrest you and put you on trial, do they have to give you a lawyer? Can they, engage in cruel and unusual punishment against you? Can you speak freely and voice your opinions about, whatever political issue you want? Can you vote? No. Can you, I don't mean to put you on the spot, but could you make a contribution to the political candidate of your choice? Can you own a gun? So what is this people, right? Who are the people protected by the Constitution? So for the first 8 or 9 question I asked her, does she have Miranda? Of course, right? Does she have trial by jury? Of course. Can she speak freely? She's in this class. I hope so. Yes, she can speak freely. But once I said, what about making a contribution to the candidate of your choice? Oh, no, First Amendment doesn't apply there, right? What about owning a gun? Well, the courts are actually split on this, right? If you're, and I'm assuming if you're a resident alien, right? Basically, you're here lawfully. Some courts have held that you have a Second Amendment right. Some courts have held you don't. But the entirety of the people means we're not talking about citizens here, that this is for everyone. Okay? The next clause. Keep and bear arms. What a funny formulation, right? If we wanted to say that people have the right to own a gun, couldn't you have said it a little more directly, right? The First Amendment, Congress shall make no law respecting the freedom of speech, right? How about Congress shall make no law respecting the keeping of guns, arms? Easy, right? But they use this expression. It's not just keeping guns, but bearing guns. So keeping means you hold on to the gun yourself. What about bearing arms, right? We don't use this expression too much anymore. The majority says bear simply meant that you can have it and carry it around. The dissent said, no. Keep and bear. That means military. The way you bear arms in war. You may have heard that expression, right? The dissent says you're bearing arms for purpose of the militia. To which Scalia replies again, no. That means bear arms against an enemy. This is not bearing arms against an enemy. It's only bearing arms. You see, the textualist arguments, they go back and forth. I mean, it's not going to resolve based only on the text. Okay? So then we have the last provision, right? Shall not be infringed. Well, that's different than the First Amendment. First Amendment says Congress shall make no law, period. This says shall not be infringed. Where does this come from, right? Does this mean there can be no regulations on guns? Should not be reasonably infringed? Well, the First Amendment, even though it says no law, period, the courts have said you can have some regulations, but you have scrutiny and other sorts, right? What about shall not be infringed? Well, if you take it as an absolute, no laws, done, kaput, can't do anything. Okay, so everyone get the operative clause. Any questions on that? So then we have to ask ourselves, what's the connection between the first and the second clause? What's the connection between the prefatory clause and the operative clause? Sorry, one of my professors wrote an amicus brief for this court. I was his research assistant. The entire thing was on grammar. We had to review the 17th century grammar textbooks to discuss how commas were used. I'm not joking. This is the kind of briefing we did on this case. It was seriously detailed. How grammar, how punctuation was used in the 1800s. It's crazy stuff. So Scalia says the prefatory clause only kind of gives a statement of aspiration, right? It doesn't really define the purpose of the law. It says, you know what? Having militia is very, very important. And oh, by the way, private ownership of guns can't be restricted, right? Scalia's opinion has to fudge here a little bit because, as the NRA banner shows, that language is not very helpful to an individual right. It really isn't. And you have to acknowledge that and be candid about it. I think Scalia perhaps is a bit too glib about this point, even though I think it's probably right in other respects. The dissent, or Justice Stevens, says, wait a minute. This is not some sort of like aspirational purpose. The first clause informs the second one. The right to bear arms only exists to the extent it serves the militia, Stevens says, right? Scalia counters, of course. Well, wait a minute. Look at all these other provisions of law. So, for example, I'm going to read from you something called the Northwest Ordinance. This is a law passed by the Confederate Congress in the 1780s. And I'm going to read it to you. It says, religion, morality, and knowledge being necessary to the good government and the happiness of mankind, schools and the means of education forever be encouraged. In other words, because knowledge is so important, education shall ever be encouraged. In other words, this was a prefatory language to just say, here are some interesting facts, but now let's get down to business. Okay. Who's right? Scalia or Stevens? Based on the text, I will let you decide for yourself. Okay? So we spent almost 40 minutes of class time discussing 26 words in an amendment. And I'll ask the question again. Should we be deciding issues as important as gun control based on 26 words, which, I don't know, maybe go either way? They move on, though, from text. Now, while I think that Stevens probably gets the better on the text, Scalia gets the better on history, okay? And specifically the history from which the Second Amendment arose. And as I discussed a few minutes ago, the English monarchs were very good at having standing armies. And the first thing these standing armies did was take away the guns of the people. Because once the people are disarmed, they can't fight back. Tyrants love this. Yes, sir.
If you take the meaning that the militia, I guess, were the main focus of the amendment, and you're saying that the militias had the state's interest in mind as opposed to the federal government, could you then read in that the states had a right to insurrection against the federal government? Is that
what did Thomas Jefferson say? What did Thomas Jefferson say? Go page 9. All right. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another. What did Jefferson say? Yes. I mean, I know this today is a, you know, we don't think about these things, but at least in the founding generation, the idea of armed insurrection against a tyrannical government was like, you know, a way of life, right? They had just fought a revolution against their mother country because of an overbearing government and like high taxes, right? So the idea that if the federal government became tyrannical, that the states could march up in rebellion. Yeah, I mean that was a serious, legitimate concern.
So then if we take it back to the right of individual, then does the individual have the right to insurrection? I mean, that would be the logical conclusion.
Yeah, and if individual gets together with a group of his people and decides to have a revolution, then yes. I mean, one man perhaps can't take down a country, but if he has a bunch of his buddies, yeah.
And it would ostensibly be constitutional.
Well, I'm going to ask this question seriously. How do we change the Constitution? What's the process? Or revolution, right? So thank you for saying that. It saved me two questions, right? Once you get to the point where people are taking up arms, the amendment process doesn't really mean anything anymore. And I know this is a jarring thought, perhaps not in Texas, right? I mean, Texas, I'm learning my Texas history, but this country, well, it was a country, a republic was born by a bunch of guys that screw this, we're going to fight. You know, it's interesting living in Texas. I'm not from here, but I sense the DNA of Texas that you do have this sort of spirit, which I don't think exists anywhere else in the country. New York's like, oh my God, government, please help us. Here it's don't mess with Texas, right? So best litter slogan ever. So to answer your question, Hector, yeah. You know, Jefferson also wrote, and I'll stress this, he wrote, you don't rebel for, quote, light and transient causes, right? You don't throw the government off because, you know, your property taxes are too high, right? To Jefferson, at least, it was a serious deal. He famously wrote that the tree of liberty is watered by the bloods of the patriots and tyrants. So he was very much in favor of armed insurrection. In fact, Jefferson actually did the math. And he said, based on the average lifespan at the time, there should be a new government every 20 years or so that the blood of liberty is fresh. He actually did the calculations and everything. They should have armed insurrection, I think, every 19 or 20 years. So I think for a good old Tommy boy, we're perhaps overdue. Other questions? Okay. So the history of the Second Amendment, and this is where I think Scalia gets the better, was very much in tune with an individual right, totally separate from the militias, right? There were no militias in England when King Charles and King James tried to suppress political dissidents, right? There were no militias. But the English Bill of Rights, the Declaration of Rights, provided that the people, actually just the Protestants, screw the Catholics, right? Serious. The Protestants could not be disarmed. It actually says Protestants in there. The Catholics were on their own. Sorry for the Irish, not very lucky. So Scalia says, listen, this history is a clearly individual right. Scalia looks to William Blackstone, who's the great jurist who gave us our commentaries, who said the right of resistance and self-preservation is a natural right, right? That the right to have guns is about protecting yourself. This is a very Lockean idea that, you know, in the state of nature, your number one defense is to save yourself. So the history, though, right? The history was largely grounded in terms of individualism. And Stevens has to somewhat gloss over this history because it doesn't help him very much. He focuses almost exclusively on the text and the drafting history of the law. So what do? We have history cutting one way, and we have the text maybe cutting another way. How are judges supposed to resolve this difficult issue? Now, Justice Breyer's dissent, which was unfortunately omitted from your book, making your reading even shorter than it should have been today. Justice Breyer's, yeah, you're welcome. Last day of class, full of bird. So Justice Breyer's opinion, which wasn't included in your book, basically makes the point, and this is his number one thing: democracy, right? As judges, if we have a close call, right? If we have a close call, the text goes this way, the history goes this way. I don't know. Breyer says, let's defer to the democratic process. Let's let the District of Columbia make up their minds about how things should go. This is Breyer's never-ending, what we've called the presumption of constitutionality, that we will just assume that laws are valid because democracy. One second, Plumman. Majority, Scalia says, rubbish, right? Or grotesque is his actual word. I love that word, grotesque. Scalia says this is grotesque. He says the Second Amendment and the Bill of Rights are meant to take decisions out of the hands of government. If anything, we should be giving a presumption of liberty. And for those of you who like footnote 4 of Caroline Products, remember what we said about rights listed in the first 10 amendments, that they get heightened scrutiny? Justice Breyer forgets that. He actually cited footnote 4 for the exact opposite proposition, and he screwed that one up big time. Plowman. It'll be the first time.
As far as leaving things to the political process, when we're talking about this issue in particular, when the political process is so influenced by well-funded lobby groups like the NRA, for example, are we really leaving it to the democratic process, or is it something else entirely?
Well, in this case, the District of Columbia was not lobbied by the NRA. They banned the possession of all firearms.
Yeah, but in general.
In this case, is not that legislature will give too much rights, or they won't give enough, right? So it's not the issue of the people giving too many rights. It's that gun control laws are restricting the rights, right? That. Yeah, some more than others, yeah. Right. So this part, though, yes.
Well, isn't it like the Supreme Court's job to, so they say, to interpret like the Constitution? So why would you leave it up to the legislature?
Well, Justice Breyer says the text goes this way, the history goes this way. Let's let democracy decide. Scalia, as you said, wait a minute, we're the Supreme Court, right? We are the final arbiters, and if we have a dispute with the Constitution, we will, by our best lights, interpret it.
Doesn't Scalia use that argument in other situations? It's just for this situation, he thinks.
Which situations are you talking about?
Well, I've heard something on the NPR about gay rights.
So how would Scalia respond to that argument? How would Scalia say Roe and Casey bad, Heller good? How would he respond? No. Really easy answer. This one's easy. Defend Scalia. Roe and Casey are ridiculous, but Heller's good. How would he defend this? What? No, it's really easy for Scalia. This is an easy one.
Well, his whole thing
No, raise your hand. Yeah, go for it.
Sorry. His whole thing is that the Constitution died basically of all of the ink dry. And yet here he's saying, oh, no, it's alive. Just because that's what it meant back then, that's not what it means now.
Oh, no, that's entirely wrong, in fact. What he's saying is that we should make it mean what it meant back then. But why is it okay for Scalia, right, to say these unenumerated rights like abortion and sodomy are crazy, but guns are okay? More than originalism. The text! It's in there. It says armed. It's right in there, right? This is, I'm not defending Scalia, but his defense would be like 1 second. Duh. There's nothing about abortion or marriage in the Constitution, but hell, it says right up there, it's number 2. It's like the second thing they did, right? That doesn't resolve the issue. But at least for Scalia, and this is why that part of footnote 4 makes sense, if something's listed in the first 10 amendments, it's probably important and the court should give it some more oomph, if you will. Anything else? Sorry, I didn't mean to cut you off, but it's exact opposite, right? Scalia is not saying that we should have a living Second Amendment, right? He's saying we should interpret it based on how it was originally understood. There are problems with this, which we'll discuss in a couple minutes, with respect to the types of guns allowed, because AR-15s didn't exist in the 1800s, right? But Scalia tries to handle that. We'll talk about that in a minute. Any other questions on this? Okay. Okay, so we have here, right? We have this history. And the majority says the Second Amendment protects this individual right. The dissent says, well, the Second Amendment only protects this individual right when you're serving the militia. Dick Heller was not a member of the militia, therefore he has no right to have a gun. Okay? Fine, right? That much is straightforward. Okay? But then we get to the final part of Scalia's decision. Okay? The final part of his decision begins with famous words. This right is, quote, not unlimited. Right? This portion of the opinion, I'll give you some inside baseball, was the work, the hand of our ever-present, omnipresent Lord, Anthony Michael Kennedy, who's currently sitting on his throne in Washington deciding who, thumbs up or thumbs down, if you ever see Gladiator, right? It's something like that. You shall be entertained. So Justice Kennedy was very active in our argument, saying, well, you know what? Cool, guys, you can have the Second Amendment, right? But what about gun control laws, right? Gun control laws came into force in the last, half century without a Second Amendment, right? Our entire regime of gun control laws was premised on the idea that if the state determined something was dangerous, they could regulate it, and there's no constitutional barrier to get in your way. And I swear to God, this comes up in every Second Amendment case. What about machine guns? Okay. The only reason why people know about machine guns is they watch Dirty Harry or they watch some movies like, oh my God, we can't have machine guns. Okay, let me tell you something. If anyone ever fired a machine gun, they're not very accurate. They spray over the place. They're not very good weapons, okay? These are not the things you worry about. Virtually every single crime in the United States involving a gun is with a handgun, okay? Rifles are not used in crimes because they're not very effective for this matter. Okay, put that to the side. But everyone's afraid of machine guns. And the question which the court posed to Alan Gura is, what about machine guns? Okay? And Alan, who is, again, a dear friend of mine, had to make a very strategic decision. The answer has to be machine guns can be regulated. That has to be the answer. Because people have this insidious image of, Dirty Harry running around just spraying bullets everywhere. Okay, so then what is the limit? What is the limiting principle in the Second Amendment? First, we discuss what type of arms can be limited, right? And as I mentioned a moment ago, in the 18th century, the types of weapons people used were muskets, right? These long guns that have little balls and you put powder, goes boom, right? They weren't very effective. They weren't very accurate. Okay? So the dissent suggests, but not really, that the only types of guns that should be protected are muskets, right? Only those guns which exist in the 1800s are allowed. Justice Scalia says his argument borders on frivolous. Why is it frivolous? Are we really going to say the First Amendment only applies to a printing press and not a typewriter or a computer or a internet? Are we really going to say that? Of course not. Are we only going to say that the Fourth Amendment applies to investigation techniques that existed, or it applies to things like wiretaps and surveillance cameras? So the court has been very good at carrying technology over and trying to apply these constitutional principles in a manner. But that doesn't resolve the issue, right? Because the weapons we have today are very different in size and scope of what existed 200 years ago, in much the same way that the internet has a much wider reach than any printing press ever will. So what does Justice Scalia say? And this, I think, is probably the weakest part of the opinion. And this is the, oh, please, Anthony Kennedy, don't dissent part of the opinion, right? Where the court looks to Miller. This was a sawed-off shotgun case from, was it 1939, right? And in Miller, the court said that the sawed-off shotgun can be regulated and taxed because it was not the type of weapon that could be used in the militia, right? It's not a very good militia weapon. Wait a minute, Josh. Didn't we just spend an hour talking about how the Second Amendment has nothing to do with the militia? Well, yeah. So this is probably the weakest part of Scalia's opinion that drives everyone batty. Other stuff too, but this one drives me batty. Even though the Second Amendment is an individual right, not connected to the militia, the only guns you can have are those in common use that the militia could use. Try and figure that one out, right? Even though, right, the Second Amendment's individual right, the only guns you can possess are those in common use that can be used by the militia. Okay, Jason.
Military police use short barrel shotguns all the time.
And this is the ridiculousness of Scalia's opinion. If we're actually, and I say this, I agree with the opinion, but this part's ridiculous. If we actually make it serious of what weapons are used by the militia or by the National Guard, AR-15s are covered. M4s are covered. Basically, everything's covered. Go look at Baltimore, look what they're armed with. They got everything, okay? If we're actually saying that only the weapons used to preserve the militia are acceptable, they are armed to the tooth. This would also be the right to a SWAT van and, whatever battering, God, pepper, tear gas, whatever, right? Or whatever, flash grenades, whatever. They use everything. So this aspect of Heller leaves, shall we say, a lot to be desired. So the scope of what weapons are protected by the Second Amendment has still not been resolved. And yesterday, you're lucky I didn't sign it, but yesterday, the Seventh Circuit issued a decision, which I haven't fully read yet, saying that the state can ban so-called assault rifles. And this is a term which drives me nuts because it doesn't mean anything. So the phrase assault rifle is invented to scare people, right? It has nothing to do with the actual gun. It refers to cosmetics and various aspects of how the gun looks. There's nothing about assault rifles. Assault rifle is not an automatic weapon, right? They're all semi-automatic. What does semi-automatic mean? You pull the trigger once and one bullet comes out. If you pull the trigger and it goes sprays, right? That's a machine gun, automatic, and totally different deal. Those are significantly subject to federal regulation. But a semi-automatic rifle is basically not. And some states have tried to ban those, and the Seventh Circuit just upheld that ban. That's probably going to the Supreme Court. So the court doesn't really make clear. What they say is the quintessential weapon for self-defense is the handgun. Why? Because that's what Americans use. This again is where Scalia's opinion drops. If you actually want to be serious about gun crime, as Breyer says, almost 80% of gun crimes are with handguns, not rifles, handguns. So if you want to ban a gun that was dangerous, you'd actually ban the handgun. Scalia's like, well, you know, but people use them, so gosh darn it, they're okay. Scalia was being a little bit too cute, right? But the bad part is the court hasn't revisited this case in 8 years. Okay, even though McDonald was decided in 2010, that only resolved the incorporation question, said nothing about the scope of the Second Amendment. And the court is denied certiorari on case after case after case after case after case after case after case, right? They just kept denying everything, which drives me insane to no end. Hopefully they'll grant one case eventually, but who knows? Then we get to the key part of the opinion, which is the paragraph that begins, although we do not undertake an exhaustive historical analysis of the full scope, nothing in our opinion should be taken to cast doubt. And whenever the page, just call it out. Although we do not undertake the exhaustive historical analysis of the full scope of the Second Amendment, nothing in our opinion should be taken to cast doubt. And we got it? It's towards the end of Scalia's opinion. Which one? 1203. Yep. Just turn there and put a big box around that. Yeah. Although we do not undertake an exhaustive historical analysis of the full scope of the Second Amendment, nothing in our opinion should be taken to cast doubt. And here the court lists 3 things that have basically defined the Second Amendment in the last, 7 years. I feel old. 7 years. I remember reading this case the day it came out. I read the entire thing straight. I was like giddy. I was actually in Los Angeles, and I woke up at like 5 in the morning whenever I used to get there early. It's a 3-hour time difference, and it was an interesting day for me. So, what's the first thing that this analysis does not cast doubt on? Long-standing prohibitions on the possession of firearms by felons and the mentally ill. So the first word there tells you a lot. Long-standing. By long-standing, they mean before 2008. That is, laws that came into existence before the Second Amendment meant anything. So think about that for a second. What the court's basically saying is that laws that came about before we actually recognized this right, those are fine. Even though, had they been passed today, they probably wouldn't be. This is like saying, yeah, we just recognize this First Amendment. We can keep all these laws banning, speaking out against the government because they're old, they're long-standing laws. This drives me nuts. So we have here this discussion on possession of firearms by felons and the mentally ill. We have significant laws in this country that say if you are a convicted felon, I mean, you're out of jail. If you're in jail, you can't have a gun. But once you get out of jail, you basically can't have a gun. Governors can provide those rights, but it's complicated. Federal felons need to seek a federal pardon, right? So if you're Martha Stewart, you're a convicted white-collar criminal, you cannot own a gun. Congratulations. What about the mentally ill? Well, this is a big issue today in various states. If you have some sort of history of institutionalization or otherwise, you are put on various lists that you can't purchase a gun. A brief note on this, something which you may not be aware of, but the overwhelming majority of people with mental illness are not dangerous. The overwhelming majority. And there's actually a serious threat, if you talk to healthcare professionals, that these sorts of laws stigmatize people, make them not want to get treatment. This is not a legitimate concern. If you know that if you talk to your doctor and they may find that you're dangerous, take away your gun, people won't get treatment. And New York just instituted a massive new regime which gives doctors basically the right to take away a person's guns. There's actually a chilling of treatment, which might be counterproductive. Not resolving, but to tee it up.
How does that, with HIPAA though, how does that like work?
The New York law is very, there was a New York Times article about this a few months ago. It's a very poorly worded law that allows a doctor with very little process to petition to have a person's gun taken away from them. It's a very, maybe the heart is there, but the way it executes, I think, violates due process in a lot of ways. Doctors sometimes disagree about a person's mental health. These aren't, you know, these aren't not like a judge verifies. It's based on a petition. All right? So that's the first prohibition. The second one says, our opinion should not cast doubt on laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings. Remember, Prince of the United States came to the court as a gun-free school zone case, right? And the court was very familiar with it. I mean, I can't bring a gun to the Supreme Court. Hell, I can't even bring a camera to the Supreme Court. We know that all too well. So the court's saying, you guys have guns, just don't bring it to our place of work. But I wanted to, this provision has basically been read by a lot of people saying, wait a minute, this means you don't have the right to carry a gun outside the home, right? Some states don't allow carrying outside the home. But wait, I counter. Check this out. If the government can regulate carrying in sensitive places, what about unsensitive places? The very fact that you can regulate carrying in sensitive places suggests that in unsensitive places, the regulations are different. So the way I read this, and then again, people can disagree with me, is that this recognizes some right to bear arms outside the home, although it can be regulated in places that are sensitive. This court, the circuits have split on this. So some circuits have said, yes, you have a constitutional right to carry to the home. Some say you don't. The court will eventually have to resolve this. This is the biggie, right? Virtually every state allows a carry permit, but there's a difference, which I'll explain, between shall issue and may issue. Okay, a shall issue permit works like this. I apply for the permit, I take the class, I pay the fee, I get a permit. They can't tell me no. May issue says you have to prove to the state why you have an exceptional fear for your safety that you need a gun. In other words, the burden is on the individual to prove to the sheriff that I need this gun. And saying, I fear crime is not enough. They'll say, well, we have a police department, don't worry about it. You have to show an exceptional need, maybe if a business has cash or something, right? And these permits are routinely denied. The court will eventually have to decide whether these may issue regimes where a person needs to plead why they want to exercise their right, if that's constitutional or not. Yeah? It could. Yeah, so there's an article in the New York Times, I linked to it, I'll send it to you later, where the psychologists are basically saying that if people know that if they talk to a doctor and say, I'm having these thoughts, or my head's bothering me, if they know that their guns will be taken away, that actually chills treatment, people won't open up. And that mental health professionals are actually worried about these sorts of regimes spreading. And it might actually have a counterproductive effect. I'll send you the link later, I don't have the top of my head. Yeah, it's an issue which people don't think much about. Right, but when you stigmatize treatment, people get less of it, which is not always a good thing. Okay, the final of the third that the court mentioned is laws imposing conditions and qualifications on the commercial sale of arms. So we're not saying that, you know, you can buy and sell a gun whatever you want with no regulation. They're not saying that. If you want to have someone have a background check or maybe a proficiency exam or, you know, fingerprints, whatever, we are not saying that you can't do that. What the court is saying is that you can't ban the sale of guns, right? Right. You can sell them subject to various regulations and qualifications, but you can't prohibit it altogether. So the court is doing a lot of work in those three sentences, both affirmative and negative, saying, right, we're not striking down these laws. Oh, but by the way, these laws are safe, right? They're trying to dance on both feet. Okay. What about the weapons, right? The test they use is this, quote, you can have weapons that are in common use. You can have weapons that are in common use. When? Well, common use today for the militia. As Jason mentioned a moment ago, that would mean just about every gun you could imagine, because they have a lot of guns. The National Guard, go turn on your live stream for Baltimore, they have a lot of weapons. And they use them all. Okay? And then he adds, oh, by the way, it can't be dangerous and unusual, whatever that means. But what's an unusual weapon? A weapon that's not in common possession, which includes a machine gun. And why is a machine gun not in common possession? Because it's been basically impossible to buy for 70 years, right? So that the government's been banning weapons for so long, or actually heavily regulating weapons for so long, that they're not in common use, they're unusual, therefore they can be banned. You see the circle, right? It's basically maintaining the pre-Heller status quo, except for a few carve-outs for handguns in District of Columbia, right? It's this weird opinion. Okay? So once they actually turn to the actual DC law itself, it's fairly short. That opinion was not very long, right? Can the DC handgun ban stand? No, it cannot, the court says. Why? Because they're banning an entire class of arms that are necessary for self-defense. Whoa, where'd you get the self-defense thing from, right? I thought this was against tyranny, right? So we have the Second Amendment to fight against the tyrannical government. Well, where's this defending your home business? Again, here Scalia also fudges a bit, right? He says it's for defense of home and hearth, right? You can defend your home against an invader. He actually made this point that, you can have a handgun in one hand and your cell phone in the other calling the police. He actually made this point, right? So after all this stuff, we have that the government cannot ban a possession in common use for purpose of self-defense, right? If the weapon's in common use for self-defense, it cannot be prohibited. They can impose various regulations how you can acquire it. They can impose regulations on where you can carry it. And if you're a dangerous felon or a mentally ill person, they can keep a gun away from you. All right, so what did Heller change, right? Did Heller change much? This is a big contract of discussion. Well, to date, all the Supreme Court recognized is that both Chicago and the District of Columbia cannot ban the registration of guns at home. They have not taken a single case involving concealed carry outside the home. They've not taken a single case concerning what types of guns you can own. They've not taken a single case about licensing fees. In some states, they're hundreds of dollars to get a gun license. It's ridiculous, right? They've not taken anything. Why are they not taking the case? Maybe because they're afraid Justice Kennedy will go the other way. Maybe in the same sense that the NRA didn't want to bring this case in the first instance. Now they're afraid, maybe Kennedy won't go for this, and you'll basically cripple the right. So we have this odd détente, a truce, if you will, where the Supreme Court just denies certiorari one after the other, and maintains the Second Amendment right, which floats in the ether. The big question, which wasn't resolved, scrutiny. What kind of scrutiny do we apply? And we just discussed the First Amendment, and we said, well, sometimes you apply a strict scrutiny, and sometimes you apply a rational basis scrutiny, and sometimes you have this weird intermediate scrutiny with all these other tiers, right? Wouldn't it be awesome for Heller to tell us what kind of scrutiny to apply? As Justice Breyer points out in his dissent, they didn't. They made no effort to announce it. All they said was that we're not doing what Breyer does, right? Basically, all they said was, whatever it is, it's not what Breyer said. Breyer wants it was famous interest balancing analysis is where you balance this and you balance that and you balance handgun violence and you balance urban area and you balance whatever exists in the founding era, and then you balance this and you balance that, and you have like an 8-balance scale, right? And then you put your thumb there and whatever, and then you say the gun law is okay. The majority says this is ridiculous. No other right in the Constitution is subject to this sort of balancing test, right? We don't do this kind of balancing in constitutional litigation. If it's a fundamental right, it's in the Bill of Rights, we give it scrutiny. What kind? Who knows? So all we know is that it's not rational basis. And the court says, listen, we're not doing a rational basis. What is it? So the lower courts some have said it's strict scrutiny. Some lower courts have said it's heightened. This is the key word. Everyone loves the word heightened. It's not intermediate. It's heightened scrutiny, right? What difference does it make? What difference does it make what kind of scrutiny you use? Well, it makes a big difference. And think about it this way. This is a point I've made a number of times. When you're dealing with rational basis scrutiny, the burden is on the individual to show why the government's wrong, right? And usually in constitutional litigation, note for your future practice, when you have the burden, you're probably going to lose, right? When the burden's placed on you, it's a heavy burden, and you can never throw it off. Strict scrutiny, the burden's on the government, and the government needs to say, why are we infringing this person's rights? And usually when the government has a burden, they lose. Depending who you place the burden on. If you place the burden on the gun owner, say why they need to have a gun, why they feel scared or threatened, or if you put the burden on the government, say, why are you depriving this person of this right? It changes the entire calculus. If we start from the presumption that the state has this paramount interest in safety, and we need to justify an exception to it, right? We need to explain why we need these things which can be dangerous. Oh, then gun laws are looking very reasonable. This is Breyer. Majority says, no. This is not paramount safety. It's a paramount liberty, right? Freedom is the starting point. And the government needs to say why you need to carve out exceptions. To use an example, I think I mentioned the first day of class. The first few sees government as this massive sea, the sea of government, these little islands dotted of liberty. You have a little Liberty Island there, you have Ellis Island there, you have little islands everywhere. And the Scalia opinion is like, it's the other way around. You have this massive sea of freedom. And you have these small carve-outs for government, these small islands of government throughout. And this is really the fundamental divide between Breyer and Scalia. And you see it in this case, and you see it in every case we study where they've fought. And they're not going to agree on this one. And not that one's right or wrong, but they see the world in a very different place. Breyer's like, listen, we have all these studies saying guns and crimes. And even if guns reduce crime, shouldn't that be a judgment that the legislature makes, not us unelected judges? Breyer says, you know what? If this is so dangerous, it's not for us to make a decision. Let the elected branches do it. And Scalia says, no, it's in the Constitution, which means we take it out of the political process. And it's fascinating to juxtapose the arguments concerning abortion and gun rights, because I think as Morgan hinted before, on the one side you have Scalia saying, political process, and Breyer saying, no, we have to protect this. And you have in Heller, oh, no, Breyer saying political process, and Scalia saying, no, we have to protect this liberty. So there is an odd juxtaposition, although in Scalia's offense, there is a gun amendment, there's not an abortion amendment. So where are we today, right? Where are we today? Well, in the 8 years since Heller was decided, the court has taken one Second Amendment case, and that was a case concerning the city of Chicago and McDonald, the city of Chicago. And this is Otis McDonald. He lived in Chicago. He died in the last year. This is Otis McDonald. Oh, by the way, this is a cool picture of Heller and McDonald together. They're plaintiffs. And this is a picture of Dick Heller after he got his a gun permit. They finally let him register his gun. Yeah, he's guy's a loon. He's a nice guy, but he's very eccentric. Let's put that nicely. So McDonald was a guy living in Chicago. Okay, so here's our chronology. Once Heller was decided, the next issue was incorporation. Does the Second Amendment apply to the states? I am not joking. Before Heller was even decided, Alan Gurr had drafted a complaint we filed in Chicago on Heller's decision. I think within a few hours of Heller's decision, a lawsuit was filed in Chicago challenging the Chicago handgun ban. The NRA also filed their own case because they wanted to be cool now, right? The history comes back. So both Gura and the NRA filed lawsuits in Chicago challenging the city of Chicago's ban on handguns. And this went up to the Supreme Court, and this is a case I actually worked on extensively. The court held that the Second Amendment applies to the state. And now we had this idea that the Second Amendment applies nationwide, applies everywhere, and applies exactly the same way. There's no difference federal and state standard, which is what Justice Stevens would have wanted. We discussed before, Justice Thomas had a concurring opinion where he said, wait a minute, this entire incorporation business, the due process clause, none of that. Privileges and immunities, right? That the Second Amendment is a privilege or immunity of citizenship, and applies to the states. So oddly enough, there were not 5 votes to incorporate through due process. There were only 4 votes to incorporate through due process, and Thomas alone incorporated through the Privileges or Immunities Clause. And that brings us till today. The court still has not granted any Second Amendment cases, and we don't know what this doctrine means going forward. I'm hoping that the case decided yesterday by the Seventh Circuit involving the so-called assault weapons ban will make to the court, and maybe also more cases to write and teach about. Okay. Questions? Yes, sir.
Well, mine is more in regards to the assault weapons ban. I just have a question about it. So I understand that I think it was in 1993 when they passed that law supposedly banning assault weapons, but wasn't there a huge controversy saying that like assault weapons was like a term that was created by the media in order to sort of incorporate like single or anything that's basically not fully automatic weapons that look aesthetically like machine guns and try to ban?
Yeah, I mean, I don't mean this too glibly, but it was a term invented by people who don't like guns to make them look scary. The phrase assault weapons is cosmetic. It's how it appears. It has nothing to do with its actual functionality. So there's not much. It doesn't really mean much.
And so how do they allow for that law to pass? Because I mean,
Well, in 1993, what did the court say about the Second Amendment? Exactly. And that's exactly the point. There was no constitutional challenge to the Brady Act in 93 because there was no Second Amendment. That's why they brought prints based on commandeering as a way to get around the Brady requirements. They couldn't bring the Second Amendment case. They weren't there yet. Yes, sir.
I know it's a little bit on topic, but I just want to get your views on what do you think of the militarization of police force, military weapons, how these forces, you know, local universities, like I'm looking at why did you teach me?
Don't ask the Aggie fans, right? So if you want to read more, there's a good book which I'll recommend. It's called Rise of the Warrior Cop by Rodley Balco. It was published about a year or two ago. It's called Rise of the Warrior Cop, the Militarization of America's Police Force. This is not my area of expertise, but this book did very well, and I recommend you read it. And it discusses how those perverse incentives where federal money is available for local police departments to buy these bobcats and tanks when they don't really need them. And then, oh, by the way, when you have bobcats and tanks, oh, they're cool, let's use them, right? It's this bizarre thing that when you give someone a toy, they're going to play with it. So when you give, an MRAM tank to a police department with 100 people, they're going to use it, and they may not use it in a responsible manner. So I'd recommend this for further reading. Other questions?
I
Yes.
just wanted to add on to that. I know that there was like one city, not in Texas, but somewhere where they were trying to recruit like police officers basically, and so they were basically had flyers or whatever, and like the officers were like doing military training, like wearing military things, like.
The recruitment video. I think I know what you're talking about. Yeah, if you can Google it, there's a recruitment video where it's like, come ride tanks, join the Podunk Police Department, whatever it is, right? Yeah, read this book. It's a good book. Hector?
You said the Thomas dissent or concurrent?
It was a concurrence in McDonald v. Chicago.
Did you say the privileges and the
Or.
immunities clause?
If I said and, I mistake. It's or. I think I said or. What else? Yes, sir.
Do you think we should restrict gun rights, or do you think the Second Amendment really does?
Loaded, no pun intended. Yeah, it's transfer class. I can write a book on this. I may have to. Yes, sir. Yeah, you.
Why can't we still buy into the militia argument? I mean, it's not too far to say a hypothetical situation could occur where we're fighting Russia and Eastern Europe, China and Asia, and the former of the Straits. Let's say, I don't know, a Zimmerman telegraph moment happens where China works in Mexico and Mexico invades us because our military is fighting a three-front war.
Oh, I'm sure the bunch of Texans would muster up pretty quickly.
I guarantee I'd want the right to.
The Sealy militia will be well led. He's on the city council there. So, what else? Yes, sir.
I just wanted to mention a brief statistic. This is what about guns, I feel talking about gun violence is also important. Poland, which is one of the strictest gun control laws, about a whole deaths that occur every year, about 2%, just a little over 2% of those are caused by guns, while the same number in the U.S. is well over 60%. So we're talking about 12 people a year die in England from gun violence, as opposed to about 12,000 in the U.S. Now, of course, the use of more population, so the numbers are skewed a little bit, but it's still a very significant percentage. There is one of the token European human class.
Okay. Yeah.
Just changing how they kill them, right? We shoot them here, we got the guns over there, they just pick a different method.
Yeah.
I would make the argument that whenever Chicago had the handguns, Chicago, there was no handguns allowed. I think it was like 88 to 90% of the murders that occurred within the city were still committed with a handgun, despite the fact that they weren't allowed to possess handguns. So it isn't really.
Right. So I don't want to get too far into the statistics argument because it goes both ways, and I'm the first person to concede this. The point Justice Breyer says is, wait a minute, these statistics go both ways, right? They have statistics showing this and statistics showing that. Should the courts be involved in the business of deciding this, right? That's Breyer's point. And Scalia's like, well, usually when we have strict scrutiny or something approaching it, statistics don't matter, right? The government can't do it. So putting aside whatever statistics show one or the other, depending on your view of judicial philosophy, it really resolves in large part how these cases turn out. Okay? Other questions? Thank you all for a wonderful semester. Thank you so much.